This man says there's no way this is my child. Why? Because he had a vasectomy. Mom just gave birth. Can't afford the child. Well, what happens next? Shout out to Court Archives. Let's check it out.
Versus April Porter.
This matter is before the court on the plaintiff's motion to show cause in this matter. Ms. Thomas.
Thank you, Your Honor. In this case, the case scheduling order required the parties to participate in mediation in the month of December. And as it shows on the Register of Actions, mediation was canceled by Mr. Brundage because the defendant did not, in fact, pay mediation fees prior to the mediation. She is in violation of the order of this court, causing failure to move forward with this case. And so we were asking that we could enter a default and then just simply proceed. There still has to be a ROPA hearing in this particular matter, which it could have been done a long time ago, but it still does need to be done. And then we could bring this to a conclusion.
Okay. Ms. Canfield, what's your response?
Thank you, Your Honor. Well, first of all, I very rarely see someone held in contempt of court or sanctioned for having the inability to pay a mediation fee. Ms. Thomas did not contact or communicate with me. If she had, her information in her motion would have been correct or corrected. She indicated in her belief that I had not responded to Mr. Brundage and apprised him of what was happening when in fact I did. And I have an email communication with him informing him that I had relayed the message to my client and she was going to just contact him regarding that payment. Since then, I have spoken and communicated with my client who has the inability to pay that mediation fee of $525 right now. She just gave birth several months ago to the little one that you see her holding on the screen. She is not working. She does not have that type of money to pay for mediation. Now, that having been said, I am happy, as is my client, to informally mediate that with Ms. Thomas and her client, but I don't think that, an inability to pay a mediation fee for somebody who just gave birth and is on maternity leave should necessitate an entry of a default judgment.
Who cares? This is what they would tell a man. Who cares? That's all I'm saying. That's what they would tell a man, is who cares?
I think that we ought to be able to negotiate this. I believe that the parties themselves have spoken and come to some tentative agreements that Ms. Thomas and I can discuss further and put into a consent judgment of divorce to enter before this court. And I would ask that the court deny the motion and allow us to continue to negotiate to resolve this matter.
What's happening with regard to the ROPA action?
Typically, the person that has the child that is not of the marriage is the one that brings that ROPA action, and it has not been brought by Ms. Canfield. My understanding is that when we were at the scheduling conference, well, it was actually at the first motion hearing, and another person from Ms. Canfield's office was in attendance. It was my understanding if they were going to be bringing that action, but I've heard nothing from Ms. Canfield since that. Well, and she wasn't here that day. I've heard nothing from her on this case at all.
If she doesn't do it, Ms. Thomas, you're going to have to do it, or there's going to be an order entered, and he'll be declared to be the father. And
no, I understand
and
that.
he can pay for 18 years or more if he wants.
No, I understand that, but when I was told by counsel that they were going to bring it, I assumed that that was going to happen. And I've written a couple of emails to the gentleman, and I've not heard back, so I don't know.
Ms. Thomas, may I ask you who was present at that hearing?
I
You
don't
have
know
an
his.
attorney who's left the office.
It could well have been. I don't know. I have his name in my other part of my file, but I don't have it right here.
Regardless, Ms. Canfield, is your intent to proceed with the ROPA action, or?
Absolutely, Your Honor. We will get that filed.
Okay. My staff says Attorney Crow.
Thank you. That explains things, Your Honor. We don't have the best notations to the file sometimes. So I will definitely get that motion filed and we'll get that conducted.
Okay, well, let's do that. In the meantime, if the parties wish to get together to resolve the issues, if they feel that they can discuss the matters amongst them and get them resolved, then fine. If not, the court will take the motion and I will take it under advisement and reserve any finding on that or Ms. Thomas's request for attorney fees in this particular matter, pending resolution of the case.
Okay, so they're going to order a DNA test for that child. Let's pause for a moment to thank the sponsor of this channel, fathershaverights.com. Did you know that prenuptial agreements are becoming significantly more common? Yes, especially among young generations like millennials and Gen Z. In fact, one of the expert attorneys featured in our prenup guide says he drafts 3 to 4 prenups every single week, and some firms draft more than 10. The truth is, far more people have prenups than you may realize. Want to know how to get a prenup before it's too late? Click the link pinned to the top of the comment section and take the first step in securing your future marriage and join the hundreds of men protecting their marriages the right way. Don't overlook the details here in this case hearing. Sure, maybe, right? Maybe there's a chance that she has no one whatsoever who could hold that baby. So it's not here on screen to tug at the heart of this man who might actually not be the father. He might not be the father. And he's allowed to say, hey, I had a vasectomy. I got fixed. The chances of this being my child are slim to none. Wouldn't you fight against it if this happened to you? Wouldn't you want to know? He's not in the wrong here. But all I'm trying to say is do not misunderstand the intentionality behind her holding the baby. I assume the attorney there says, yeah, bring the baby on the camera. Yeah, you've got nobody. The judge needs to see. You get what I mean? The optics do matter.
Thank you.
Thank you, Your Honor.
Thank you.
Your Honor, before we leave, we have a settlement conference this afternoon. Do we need to still be here for that now that with what we've just done?
No, let's proceed. We'll proceed on the ROPA action, and then we can again at that point that might get things resolved depending on the resolution of that. If not, then we'll set it for trial at that time.
Okay.
Thank you, Your Honor. Ms. Thomas, I'll be in touch.
Okay.
Thank you. Goodbye.
Oh, shoot. We've got the next court hearing here. Yo. Okay, I actually did not expect this. I didn't expect we'll get the results in this hearing.
Angelique, does your client plan on appearing this morning?
I wasn't certain. I have notified her. She is aware. She did sign a stipulation. I can call her and see if she is.
The fact that she's not in court should let you know how those that DNA test result. I might be wrong, but she let you know how that went. What do you guys think?
Available.
I mean,
We don't need to have her here, Miss Canfield.
Thank you. Good morning.
Judge's like, we don't want to humiliate that innocent woman who was trying to pin that baby on him. Again, I may be jumping the gun here, but let's see.
Judge, yes,
Good
we
morning.
agree that Ms. Thomas's client is not the biological father, and we've sent over a stipulation. Ms. Thomas, did you receive that this morning?
I did not.
Okay, we have emailed it to you. It is signed by both my client and Mr. Ramiro Gutierrez III, who is the biological father, as well as myself, and it has a signature line for yourself and your client. I just wanted to make the court aware that she agrees that Mark is not the dad.
Okay.
please let me call the case. Calling case 2023-1819 DM, Mark Porter versus April Porter. Today is Monday, February 12th, 2024 at 9:03 a.m.
This matter is before the court on the plaintiff's motion to determine child born out of.
Why is everyone so sad? They should be cheering this man's look. The only person that looks happy here or less upset than before is the victim here, who's the victim of a false paternity, could have been. And everyone here is sad about this situation. They're not mad at the mom for trying to do something illegal. Why the long faces? Only Abraham Lincoln here looks happy to me.
Wedlock. There was some discussion before we went on the record, Ms. Canfield, that she had sent over a stip signed by her client acknowledging that, in fact, the plaintiff is not the biological father. Obviously, looking at the time frame when the last sexual relations occurred and the birth of the child, he possibly could have been. Do we have any DNA testing in this matter?
I don't believe DNA testing has been conducted, Your Honor, but it's my understanding that there was a medical procedure preventing Mr. Porter from bearing any other children with his wife.
Okay.
That's correct.
Yes. Okay. Well, I understand that, but let's state in those instances, medical procedures are not always accurate. So the court is going to order that there be some DNA testing done. So court will have the matter done in that manner where we'll have the DNA testing. Once we get that done, then we'll set it for a Wednesday afternoon hearing at that time. So Ms. Canfield, I'll let you coordinate with Ms. Thomas to get the DNA testing done. And
I know. I actually thought they already did the DNA test, but she admitted that he's not the father. So why do you think she said that? There's something she knows that she didn't tell her attorney or anybody else here.
then once that happens, we'll set it for a hearing.
Thank you, Your Honor.
Okay.
Your Honor, all right,
Yeah.
so do you want an order prepared indicating that is question one? Question two is, as far as payment of that DNA testing, is that the defendant's payment?
Yes, I'll have the defendant responsible for that. Ms. Canfield, you may want to check with Mr. Magnuson, and maybe we can get something coordinated through front of the court and do that at a nominal charge.
Thank you, Your Honor. I know that I believe she's residing out of state, so that might be
Oh,
the difficulty.
I think Mr. Magnuson has, we have other cases like that. I'm pretty sure that he can do it through the same DNA test company and still get that better price. So I think that will work.
I'll coordinate that and then let us know when we need to set a hearing.
Thank you.
He's the one asking.
Whoa. All right, let's check out a few of these comments, see what the people have to say. Top commenter here says, child support should never be paid, in my humble opinion, unless there has been a paternity test. Somebody else here says, many of these cases can be shortened by simply doing a DNA test. I agree. Somebody else here added, judge seems disappointed, that's exactly what I saw, that he can't stick it to the male defendant. Somebody else responded back to that comment and said, well, of course, because the courts get a cut of all finances related to family matters. Somebody else who says, all judges do that. They make it so difficult for fathers. It's ridiculous and sexist. Somebody else here says, proof that child support from the father is more important to the court than whether the father is the father of the child. Here's somebody else who says, paternity fraud should be a crime that comes with prison sentence. She pretty much conceded and seems like moved away out of state. There's something that she wasn't telling everybody. There's something that he knew. And of course, obviously, he had a vasectomy. Here's somebody else who added, she should be paying for the DNA test. Another person who says, oh, Mark, you dodged an 18-year sentence. Somebody else who says, and it would have been the longest 18 years of his life. Somebody else who says, if she is not working, does not have money, why get pregnant? That's the question, right? That's the big question, of course. Here's another person who says DNA testing should be mandatory at birth. Of course. Somebody else who says, I'm so disgusted how biased family court can be against fathers. I have a neighbor that has some college education and could work, but chose to have 2 kids and live off taxpayers. Wow. This female commentator says, so mom in the first case can't pay mediation, but she can pay for an attorney? Mm-hmm. All right. That's a good question. Good observation. Somebody else who says that poor child is doomed. Another person who says newborn in court for sympathy should be a contempt charge itself. Exactly. This person says, I saw a case where a woman brought a baby to eviction court. She was months behind on her rent. Guess she brought the baby so the judge could have sympathy for her. The judge didn't have sympathy. People who are willing to use children as props in that way and just want you to feel sorry for them, and people can see right through that. But sometimes judges do fall for it. Hey guys, as always, I appreciate you checking out yet another episode of the Coffee Pod. To my currently engaged or soon to be married men, if you need a prenup and would like a guide that shows you how to get a solid and legally binding prenuptial agreement, hit the link into the top of the comment section and access your guide at fathershaverights.com today.